We are recording. I've taken attendance, and we are ready to get started. Last time we went over the ICR. If there's anyone here who was not here for the first class, if you would review the syllabus and instructor course requirements, and if you have any questions, please email me with those questions so I'm sure that you understand the rules and policies in the organization of the class. I'm not going to spend time on that today. What I did want to start talking about is the law and give you a general introduction to the legal system. The law is a system of principles and processes by which people who live in society seek to solve or settle their disputes and problems without resorting to the use of force. In order to understand the law and how it works, you also need to understand where it comes from, the different entities that create the law in terms of solving problems without resorting to force. Prior to the advent of law and legal arguing and courts, people used to solve things and settle things with their fists or swords or guns or other things. The purpose of the law is to hopefully make that less violent and more reasoned in working out one's differences. Sometimes that works and sometimes it doesn't, but that is the intent, is to resolve things more amicably, or at least in a more reasoned manner. The law encompasses principles and rules that are derived from several sources. In the American legal system, the first among these is what we call the common law, also sometimes known as the law of the case. Judicial proceedings based upon custom, common sense, and fairness began in small villages and towns in England, was brought over to this country. Originally, the common law, as made by judicial decision, was not recorded. It was considered unwritten law. As time went on, cases were recorded and were made available as reference for later cases and courts. So what had been unwritten law is now available in writing and available for review. The common law is based significantly upon the principle of stare decisis, to stand on things decided. And stare decisis is defined as the principle of following precedent. Our courts have developed a policy of resolving a case based upon the facts and then utilizing that decision when considering the next case presented with a similar set of facts, specifically by referring to a similar case previously decided and applying the same rules and principles to the case at hand. Factual differences may provide a basis for recognizing distinctions between a precedent and the current case. The policy arose to enable people functioning in society to know the rules so that they could conduct themselves accordingly. When you know what the rules are and what the law is, it's a lot easier to follow those rules and law. And so that's how that piece of it works. The common law in England and later in this country was a primary source of law. However, statutes have gradually played an increasing role in the legal system, and an increasingly important role. A statute is an act of a legislative body that may be a prohibition, a command, or a declaration. Let's unpack. Thank you, Naracha. I have you on the roster. Let's unpack that statement a little bit. So, the act of a legislative body. What is a legislative body? A legislative body is an elected body empowered to write law. So it is a portion of the government that is a body that is elected and has been empowered by underlying law, whether that's a constitution or other statutory enactment, to write law. Common examples. On the federal side, the legislature is the Congress. Congress has two houses, the House of Representatives and the Senate. Collectively, they form the legislature, and that legislature is empowered to write law. That is, their purpose is to write law. Other examples of legislatures are the state legislature, that's the state house and the state senate. The legislatures of other states, most states, that is a bicameral legislature, that is, it has two houses. Nebraska has a unicameral legislature, so they only have one house. In addition, other legislative bodies are things like city councils that are elected by the voters of the city, and then they are empowered to write laws we call ordinances for the city itself, setting out code enforcement and other types of policies and rules that apply within the city. The county commissioners court is a legislature, that is a body, elective body, that is empowered to write laws. So now that we know what a legislative body is, and a statute or code or ordinance, they're all essentially laws. A statute may be a prohibition, a command, or a declaration. Does anyone have an example of a statute that is a prohibition? And you can put your answer in the chat. So can anyone think of a statute that is a prohibition? The law telling you something you're not allowed to do.
Kill people.
Kill people. Sell drugs. Use
Slavery.
drugs. Text and drive. Slavery. All of those things. It's basically all the criminal laws on the books and lots of other things. Actually, the rights regarding voting are constitutional in nature, and so it's not really a statute. Prohibition was also based on a constitutional amendment, and then it took another constitutional amendment to repeal prohibition, so that also is more constitutional than this, since we're talking about a statute rather than an actual constitutional enactment. The Constitution is a foundational document. It is the supreme law of the land, but it's the document that empowers our legislature to write laws. But basically, all of the criminal code is based on prohibitions. That is, the criminal code provides all the things that that society has decided that people should not be allowed to do, and it sets forth what they are. What's an example of a statute that's a command? This is where the government is telling you that you must do something. Pay your taxes.
Physical.
Be in school if you're under a certain age. Wear a seatbelt. Have a driver's license if you're going to operate a motor vehicle. That is correct. Those are all statutes that are commands. That's where the government tells you that you are required to do something. Finally, some statutes are declarations. These are a little bit harder to figure out. This is where the legislature creates something. Any ideas? The Americans with Disabilities Act is a great example where they created certain rights for people and certain requirements, and they created organizations to help support the implementation. When after 9/11, they created the Department of Homeland Security. They created something new, empowered to do certain things. When they created the Social Security program back in the 40s, that was created through a declaration. And then they had additional enactments to ensure that people had things. Health and disaster declarations, all of those things are statutes that are declarations where they are declaring the need to do something or the intent to take care of something or to do something in order to protect people. Okay. So statutes, unfortunately, are not always clear. Our statutes are written not by individuals, but most commonly by committees. And when you write something by committee, sometimes it gets a lot bigger and a lot more convoluted or confusing. And when the members of those committees, a lot of them are lawyers, the language gets even more complicated and esoteric. And so that creates its own set of circumstances. So in addition to having to look at the statutory law, and in addition to courts having the power to essentially make law through their decision making, courts also have the power and the authority to interpret the law. That is, to look at the statute and to define what it actually means. And so the courts have assumed the responsibility of interpreting statutes and applying them to the fact situations presented. We see this at the trial court level, at the intermediate appellate court level, and very recently we've seen specific examples of this with the U.S. Supreme Court. Actually, this at the end of this past court session, that would be actually the first week in July, because they actually ran over about 10 days into July, which is unusual for the court, but they were out of business for about 2 months before they started hearing cases again as a result of the virus. So they ran behind. There was one case that was decided where it was necessary for the court to interpret what a particular federal statute meant. Specifically, they were asked to interpret whether Title VII's prohibition on employment discrimination on the basis of sex included discrimination against people by reason of their sexual orientation or by reason of their being transgender. And the Supreme Court, in a divided decision, ruled that the prohibition on discrimination on the basis of sex included those other areas and other individuals, because the prime characteristic that was causing the discrimination came down to sex. And so, as a result, Title VII now includes discrimination on the basis of sexual orientation and if a person is transgender, even though it may or may not have been what the original legislators intended, recognizing that Title VII was written in the 1960s. It is likely that some of this was not on their radar screen initially, or maybe not for decades. But the reasoning from Justice Gorsuch, who wrote this opinion, was that if you discriminate against one person on the basis of who they love and not another person on the basis of who they love, and the difference in who they love has to do with, or in a relationship, has to do with the sex of that other individual, that is discrimination on the basis of sex. And so that was the ruling, both with regard to homosexual relationships and also transgender individuals, that is, individuals who show to the world a different gender than they may have been perceived to hold at birth. And so we now have very specific law with regard, interpretation of law with regard to employment discrimination that prohibits this type of discrimination. Given the interpretation that has been applied here, it is very likely that those anti-discrimination interpretations will also be applied in many, many other areas of law as we go forward, such as housing and other matters. But we'll see that's going to be subject to further litigation or further action, much of it in conjunction with the interpretations of lower courts applying the decisions of the Supreme Court. So courts do get involved when they interpret and apply statutes as well. Finally, not mentioned in your book, but I want to mention now because we will talk about it later. It's in the book later, but not at this point in the book. The third major source of law in this country is what we call administrative law. It is the law that comes to us from the executive branch. You'll notice we've looked at now the three branches of government: the judiciary, the legislative branch, and now the executive. The executive branch, that's the president and the administrative agencies that report to the president, also are empowered to make law. And they do so in a couple of different ways. Administrative agencies are empowered to write rules and regulations in order to carry out the work that they've been assigned. The Internal Revenue Service promulgates rules and regulations and forms to tell you how to file your taxes. Congress sets the tax rate and what the deductions and exemptions and things are, and then the IRS promulgates rules to help you know what to file and how to file it. Congress created the Social Security Administration and created the mechanism known as Social Security, but the Social Security Administration created rules and regulations and forms to tell you how to apply for benefits and how those are considered and what your appeal rights are and all of those sorts of things. And so you have that third branch of government empowered to write rules that have the same force and effect as laws to implement what they've been delegated to do through the statutory law. Finally, the executive branch also makes law through the president issuing executive orders. Presidential executive orders are orders to agencies that the president oversees, instructing them to take certain actions. It's important to note that even when the president issues an executive order, the agency does not necessarily have the power to implement whatever they've been ordered to do under the executive order immediately. They have to follow the Administrative Procedure Act in implementing the process, which is why another Supreme Court case this term, President Obama initiated and created through executive order a program known as DACA, which was implemented through the issuance of rules and regulations pertaining to how ICE would deal with individuals who came to this country as minors illegally, that is in violation of the Immigration Act, and whether they would be subject to deportation, etc., when they'd spent their entire life here and they had no control about coming here. The current president said, well, if Obama can create it with an executive order, I can eliminate it with an executive order. And he did. However, the rules and regulations enacted by Homeland Security and more specifically Immigration and Customs Enforcement were not promulgated properly under the Administrative Procedure Act. And so in a ruling by the U.S. Supreme Court this session, the executive order itself was not necessarily found to be illegal or unconstitutional. What was found is that the rules and regulations created were not created properly. They were not published and then put out for comment and then revised based on the comments and then republished with a certain period of time before they went into effect. They tried to do it the fast way, and the fast way usually in the federal government is the wrong way, because everything the government does generally requires a certain amount of time and deliberative action. And so what was the final ruling in the court was that while the president might have the power to terminate the program, the way in which the president attempted to terminate the program and the way that the department attempted to terminate the program violated the Administrative Procedures Act, and therefore it could not stand because the laws were created wrong. Basically, the rules and regulations were done improperly and therefore could not be enforced. You still have to follow the rules. So the law in this country generally originates from three sources, and those sources match our three branches of government. So the legislature writes the statutes, the executive branch, empowered to carry out the law, writes rules and regulations and executive orders to further their requirement to carry out the law, and the judicial branch is tasked with interpreting law and ensuring that statutes and rules and regulations are created properly under the law and that none of them conflict with the provisions of the Constitution. And I agree. If you're interested in the Supreme Court and Supreme Court cases, including the ones I've been talking about today, a great resource for finding out about cases is a Bloomberg News website known as the SCOTUS blog. SCOTUS, SCOTUS, is Supreme Court of the United States. And the people who write for the SCOTUS blog are all experienced appellate court lawyers, many of whom have argued before the court in the past. And so they have a particularly clear perspective on the court and knowledge of the individual members of the court, that is, the different justices and how they write and their own peculiarities. And so it can be very interesting to give a sense of where the court's moving or what they're doing. That I enjoy reading the SCOTUS blog and keeping up with what the court's doing because it gives me a sense of where we're going. But I think the SCOTUS blog is a great site. It's free and it has lots of information. It also links to the Supreme Court's own website for finding case opinions and other information that can give you more insight into what the court is doing. In this country, the common law, principle of stare decisis, statutory enactments, the administrative actions form the backbone of our legal system. Unlike in early England, the cases decided by our courts are recorded and published, and the precedents are readily available to lawyers, judges, and all who wish to seek them, so you can find the law. You don't have to hear by word of mouth what are the rulings. Rather, you can actually look up and find the law by doing a little bit of research. Anyone have any questions about the sources of law before we move on? Okay. The rules that are at the heart of our system of justice are rules we call substantive law. They state the rights and duties of individuals and the circumstances in which a court will grant one person redress against another, and they do this by applying statutory rules and/or rules developed under the common law, or which the court's interpretation develops in order to solve the dispute. And they're based on the law pertaining to the given subject matter of the case. Occasionally, a court may determine that applying the common law rule to the facts at hand would achieve a highly unjust result. In these cases, the court may go around the rule of law by applying what we call principles of equity. In medieval England, they actually had two competing sets of courts, and depending upon what kind of relief you were seeking, you would file your lawsuit in one court, one set of courts, or another. We had the law courts and we had the equity courts. Today, most of our courts have jurisdiction both in law and in equity. That is, we don't have separate courts for different kinds of relief. A judge in a Texas district court is empowered to issue not only legal decisions, but to also consider equitable principles and award relief based on the rules of equity, should that be appropriate for the particular circumstances of the case. Generally speaking, the rules of equity are only applied where the strict rule of the common law would result in a grossly inequitable result, usually involving the unjust enrichment of one party at the expense of another party who has done nothing to cause the harm to themselves. And the book actually discusses a situation where this might arise. In the book, it notes that you have an engineer living on the East Coast who accepts an oral job offer from a company in Texas. In reliance on the offer, she and her husband quit their jobs, take their children out of school, sell their home, and move. After a month on the job, the engineer's fired without cause. The person who brought her in and hired her moved on to a different job or a different company, and whoever took over as her supervisor wanted their own person. So she gets fired. Under the common law, she would have no remedy. Texas is what we call an employment at will state. And that means that in the absence of a written agreement to the contrary, that is, an employment contract, you can fire an employee for good reason, bad reason, no reason. You don't have to give a reason why you are firing the person. They can hire and fire at will. The engineer goes ahead and files a lawsuit against the employer. She may be able to receive damages based on the equitable doctrine of detrimental reliance, because she put herself and her family in a vulnerable position in reliance that this offer of a job was in fact a real offer for a real job that was a permanent position, not a 1-month consulting contract. The reality is that very few, if any, people who already have a job would be willing to quit a good job, have their spouse quit a good job, and move their whole family halfway across the country if they knew they were only going to be employed in the new position for 4 or 5 weeks. You might take the job as a consulting contract, go work the 5 weeks and go back home. But you certainly would not completely uproot your family in reliance on something that was not, in fact, a real promise of employment. And so the court would not be able to give her her job back. But the court might rule under the rules of equity that she would get monetary damages equal to the costs she incurred. That is, no punitive damages. They're not going to punish the employer. But she could get the lost wages and the cost of her move and any loss she took on her house from where she moved from to move to Texas, and the lost wages that her husband suffered because he quit his job in reliance that she was going to have this really good job here, etc. So even though the common law would not protect her, the rules of equity would apply because her actions and changes to personal life are the type of thing that no one would have undertaken unless they thought that they had been promised a real job, whether there was a written contract or not. And so normally if there was a written contract, they would have been bound by those things. In this case, the company had the benefit of her expertise and working for them for the short period she was there, but she was there at a great detriment to herself, because when they chose to move a different direction, they left her with significant costs that no reasonable person would have incurred, but for their reliance on the promise that this offer was real, that this was a real job. It's a reason why it's much, much better to get everything in writing up front and to hopefully have a written contract. But the rules of equity do give you some benefit there and some protection. The rules of equity apply in other situations as well. When you sign a contract to purchase a piece of real property or any type of goods under the rules of law, the contract is binding, but not necessarily enforceable until you actually put your money up and a deed is passed. But under the rules of equity, the title to that property actually passes at the time you sign the original contract. Thus, if having had a signed written contract and a buyer ready, willing, and able to go through with what they've agreed to, the seller suddenly decides they don't want to sell, the buyer has the ability to enforce the contract of sale through what we call specific performance, which is another equitable remedy. The remedy of specific performance is only available if it's a contract for the sale and purchase of land, because there are no two pieces of land that are the same size, shape, and location as another. Or unique goods, that's rare artwork, collectibles, things that are not readily or easily replaceable. If you have a contract to purchase a Picasso painting, you can enforce that by specific performance. It's not like they're making any more of them, considering Picasso's been dead for quite some time. So where it is land or unique goods, the equitable remedy of specific performance might be available to you to force the contract to be completed. We'll talk about that more when we get to contract law. Ultimately, our courts apply both the rules of law and the rules of equity in order to try to ensure that the best possible result, the most fair and equitable and just result, occurs. It's also important to understand that in addition to substantive law, that is the collection of principles and rulings about the subject matter of actual issues, we also have procedural law. Substantive law gives the rights and duties of individuals and the circumstances under which the court's going to grant redress, relief from the action or inactions of someone else. Courts are often asked to resolve questions of substantive law by interpreting the statute, applying the prior precedent to a new set of facts or circumstances, looking at the rules of substantive law by relying on principles of justice and common sense. The substantive law is the subject matter. Contract law is substantive law. Tort law is substantive law. Probate law is substantive law. The law of real property is substantive law. It's the subject matter of the action. Conversely, the procedural law is a process. It's the framework under which you can enforce the law, or you can seek redress for perceived wrongs that people have committed in failing to properly fulfill what they're required to do under the law. So, whereas the substantive law will change by subject area, the procedural law is consistent and essentially the same. These are the rules by which you access the courts, prepare for trial, conduct the trial, enforce a judgment. These are the rules of procedure, the rules of evidence, the statutes of limitations, all of the rules that create the framework within which the legal system operates. The goal of the procedural law is to level the playing field. That is, everyone has to follow the same rules. You have a certain time limit to file your action. Once the other side is served, they have a certain time limit for filing a response. There are rules about how you conduct discovery, how you inquire into the other side's case in order to flesh out the issues involved and to proceed to trial. The rules of evidence govern how you present evidence at the trial. And then there are rules for how you enforce judgments once they are received. On the federal side, we have the federal rules of civil procedure, the federal rules of criminal procedure, the federal rules of evidence. and the Federal Rules of Appellate Procedure. Those rules create the framework under which you bring your lawsuit. They tell you how to file it, what the pleadings need to look like, what court has jurisdiction, etc. On the state side, we have the state rules of civil and criminal procedure and evidence and appellate procedure, along with the statutes of limitations. All of those apply in state court. So you have the different mechanisms by which you know how to handle things. And parties who access the courts are required to know what the rules are. The presumption by the court is if you have filed a lawsuit, whether you filed it with a lawyer or you filed it pro se, that is for yourself, that you have gained access to the courts with the full knowledge of what the requirements are that you need to do in order to effectuate a result under the rules. There are basically two types of disputes. We have civil disputes and we have criminal disputes. The local rules for each county's courts are also procedural law. Those local rules are the rules that tell you when or how you file things and who you have to bring things to, and what are the rules regarding having to have a conference or things of that nature. Those are the procedural actions you're required to take in those particular courts at particular times, and they apply regardless of the subject matter. The key thing with regard to the procedural law is it crosses subject matter lines, whereas the substantive law is the individual subject matter. So there are two basic types of disputes, civil and criminal. In a criminal case, the government, whether it's the state government or the federal government, brings an action against an individual to punish that individual for breaking society's laws. In a civil case, one individual, we call that individual the plaintiff, brings an action or a lawsuit seeking relief for an injury that the individual suffered. This plaintiff may be a person, a corporation, it can even be the state. And so the plaintiff is the person who is claiming they've suffered a particular harm and are seeking redress, usually in the form of monetary compensation for the loss that they've sustained as a result of the actions of the other party. And we call that other party the defendant. When someone is injured physically, the court does not have the ability to actually repair or replace the injured or lost property or body part. The court can place a monetary value on the loss by doing things like evaluating the medical costs for treatment in the past, an estimate of future costs for treatment in the future, the lost wages in the past and the future, and those intangible things, pain, suffering, loss of ability to do certain things, that sort of thing. Courts do not have the power to replace lost limbs or bring someone back to life. Our judges are not omnipotent. They can't wave a magic wand and make something go back to the way it used to be. All they have the power to do is to issue compensation, usually in the form of money damages, to provide compensation for the harm that was previously suffered. In the state of Texas, we have decided that we value people who earn more money more than we value other individuals in society, in that we have empowered the legislature, and the legislature has chosen to limit the amount of non-economic damages arising out of civil actions to $100,000. Economic damages are the damages that you can calculate based upon what someone was earning prior to the harm taking place versus what they're going to be able to earn later, or in the case of wrongful death, what their earning capacity was and what their expected lifetime or life expectancy was actuarially, which gives you a lost wages for the future, what they would have earned or been worth into the future. In that case, someone who earns a lot of money is considered to be, or receives more damages and compensation for their loss, because you can economically calculate the value of the loss. Compare that with a stay-at-home mom who's killed in an automobile accident, and the cost of the wrongful death and the damages as a result of the wrongful death of that mom are going to be based on what will it cost to hire someone to do the things that the stay-at-home mom used to do. So what is the cost to the future of someone to clean the house and cook food and do laundry and drive carpool, and to pay someone to volunteer in the school? But the maximum value of mom being home to say, "How was your day?" and give you a hug, and to volunteer at their children's school, or to participate in the PTA and all of those other things, be a spouse to their surviving spouse, those losses are capped at $100,000. And so while you can calculate the monetary loss based upon replacement cost, it is not quite what it should be. Narasha, I'm sorry that you're having connection difficulties. According to my reading, it says we're still pretty good on connection. So I apologize, but I've got green connection both directions, so it should be good. I'm sorry that you're having difficulty with it. I don't really have anything I can fix. Okay, I'm sorry it cut you off. I apologize. Cool. I'm glad it's better. Part of the problem with having to count on the internet is sometimes it's me and sometimes it's you. And sounds like it's more me than you, although I've got green, so it says that the bit rate up and down is what it should be, and I'm not having any lost audio or video. So hopefully, whatever the problem was, it's straightened itself out. Okay. So we have civil and criminal actions, and we're going to learn about both of those kinds of actions as we go forward through the course. The next thing we need to look at is the role of the court. The primary function of the court is the orderly resolution of disputes. This is based upon several factors. The first of which is the separation of powers. We have three co-equal branches of government: the executive, the legislative, and the judicial. That's the president on the federal side, or the governor on the state side, the legislature, the Congress or the state legislature, and the judicial branch, the federal and state courts. under both federal and state constitutions, each branch acts as a check and balance on the other branches. Congress can pass a law and the president can veto it. Congress has the power to override, but it takes a 2/3 majority of both houses. Congress can pass a law and the president can sign it, and then someone can file a lawsuit complaining that that law is impacting them or violating their constitutional rights, and the courts can come along and hold the law to be unconstitutional. It is the job of each of the branches of government to be a protection against any one branch of government subsuming too much authority. And it's by maintaining that balance of power between the three prongs that we keep our democratic republic form of government intact. Congress can pass a law. Congress passed in the 90s a law known as the Defense of Marriage Act. It created a definition of marriage for the federal government, and the president signed it, and it was in force and effect. And then over time, certain states changed their laws, either judicially or legislatively. The federal definition of marriage under the Defense of Marriage Act said that marriage was the union of one man and one woman. Many states then began recognizing the validity of marriage between individuals of the same sex. And then we had a problem. And in fact, an individual who was the heir and surviving spouse of a deceased person from New York filed a lawsuit against the IRS because while she and her spouse were married and legal residents of the state of New York, when her spouse died and she filed an estate tax return claiming that the transfers of property between the decedent spouse and herself were spousal transfers and therefore not subject to estate tax, the IRS cited the Defense of Marriage Act and said, since that your marriage doesn't meet the federal definition of marriage, this is a taxable event and you owe estate taxes on the transfers from your spouse. The case went all the way to the U.S. Supreme Court, and the Supreme Court ruled that the Defense of Marriage Act was unconstitutional, the portion that created a federal definition of marriage, because marriage is not something that the federal government has any purview over. It's something that is decided solely by the states. The argument that the federal government made was that if each state has a different definition of marriage, that it's unwieldy and improper that the IRS or any other government entity should have to inquire into the legality of the alleged union in the state where it was being claimed in order to determine whether or not it was a lawful marriage and therefore you were entitled to the benefits of that marriage. The Supreme Court ruled that it was unconstitutional because it was not a power of the federal government. A year later, the Supreme Court heard another case dealing with the question of same-sex marriage, the Obergefell case. In the Obergefell case, the issue was that two individuals applied for a marriage license and they were denied that license on the basis that they were both male. The court took the Obergefell case, even though there had been a number of actions filed before and attempted to be appealed to the Supreme Court, because in the Obergefell case, The Court of Appeals for the Sixth Circuit in Ohio ruled that the Ohio statute was valid. Up until that time, all of the circuits that had heard cases pertaining to same-sex marriage had held that the laws restricting who could get a marriage license were unconstitutional. The Ohio court held that the law was constitutional, thus setting up a conflict between the Oberg, no, it's FEL. I'll get you the citation for it later. I'll email you, Kimberly. I don't have it right here. In the Obergefell case, I think it's FELL, as I remember it. The court took the case because of the conflict between the jurisdictions, and ultimately, Justice Kennedy wrote the opinion holding that, thank you, Melody, that is correct. Holding that the definitions of marriage that discriminated on the basis of the genders of the individuals applying for the license violated the Equal Protection Clause of the Constitution, and that there was no genuine state purpose for making that distinction. As a result, in one stroke of the pen, the law regarding marriage in this country, throughout the country, changed. It was very interesting. I was actually sitting in the courtroom that day. I was the last person seated on the Friday where the court issued that ruling. And it's an amazing feeling to be in the courtroom with all of the justices of the Supreme Court sitting on the bench and hearing a justice issue an opinion that you know changes the law of the land forever. It was a situation which brought home for me emotionally just how powerful the actions of the court can be and how they can so directly impact people. I happened to be there for the last 3 days of the session that year. I was in DC for another purpose, and the person I was there working with had afternoons free but meetings in the morning, so every morning I went down to the court and stood in line to hear the decisions. And there were 7 decisions. Amongst those 7 decisions, I actually heard opinions delivered by 7 of the 9 justices, either majority opinions or dissenting opinions. So I heard from the Chief Justice and Justice Scalia and Justice Kennedy, and Justices Ginsburg and Breyer and Alito and Sotomayor. Justice Kagan did not issue any opinions in those last 3 days, in part because it was fairly early in her tenure, and a lot of the cases that were left she had to recuse herself from because there were actions filed by the Solicitor General's office, and she had been previously the Solicitor General of the United States. And so there was a perceived conflict of interest. And likewise, Justice Kennedy had written some concurring or dissenting opinions, but since they were not the main opinions, he did not choose to present those from the bench. Excuse me, Justice Thomas. But those are the only 2 justices I did not hear from. I got to hear everyone else speak, and it was a pretty exciting time. If you have the opportunity, once the pandemic is over, to travel to Washington, D.C. and to be present in the courtroom, either for a day where they are announcing decisions or a day where they're hearing oral argument, I truly do recommend it to you. It will be interesting to see where we're at in October as to whether the court resumes hearing cases via Zoom, where you can actually tune in and hear what is going on in the court, or if they will go back to having court proceedings in person. Given the fact that the vast majority of the justices on the court fall into a category that would be considered to be high risk as pertains to the coronavirus, I expect that unless things change substantially in the next 4 weeks, all of the scheduled oral arguments will be electronic rather than in person. And so that will afford people the additional opportunity to tune in and to hear how the oral arguments work. It was really fascinating listening this past May to a number of those cases. In this country, we essentially have two separate systems of courts. We have the federal courts created by the U.S. Constitution, and they resolve issues involving federal statutes. And we have state courts created by individual state constitutions, and they resolve issues involving state statutes and common law. In general, these courts act independently of each other and resolve separate issues. The Doctrine of Federalism states that the federal courts have purview only over those subject matter areas that are specifically delegated to the federal government. State courts have jurisdiction over everything else. And those sets of courts don't talk to each other. We have hierarchical systems of courts. On the federal side, that's your U.S. district courts at the bottom, your U.S. courts of appeals in the middle, and the U.S. Supreme Court at the top. And on the state side in Texas, at the bottom, we have Texas trial courts that have three separate levels. We have justice and municipal courts and constitutional and statutory county courts, and then we have district courts. But what they all have in common is that they are trial courts. And then we have our intermediate courts of appeals known as the Texas Courts of Appeals, and we have the highest courts. In Texas, we have chosen to divide the jurisdiction of the highest courts between civil and criminal matters. So the highest court in Texas for criminal matters is the Court of Criminal Appeals, and the highest court in Texas for civil matters is the Texas Supreme Court. And they don't talk to each other. If you don't like what the Court of Criminal Appeals did, you can't appeal it to the Supreme Court. If you don't like what the Supreme Court did, you can't take it to the Court of Criminal Appeals. They deal with separate matters. Even where you have both civil and criminal actions arising out of the same facts and circumstances, those matters are heard in separate courts and in separate court proceedings. You don't hear the civil action arising out of a matter at the same time you are considering criminal actions that arise out of that same set of circumstances. If you'll think back to the original O.J. Simpson case, there was a criminal trial where he was put on trial for murder of two individuals, and he was found not guilty beyond a reasonable doubt. After that case concluded, that is, the criminal case concluded, the parents of Ron Goldman and the parents of his former wife filed wrongful death actions in a civil case asking for compensation for the loss of their child. In the civil case, O.J. Simpson was held financially liable. Couple of factors that go into that. In the criminal case, the burden of proof is beyond a reasonable doubt. That's way up here. In a civil case, the burden of proof was way down here at a preponderance of the evidence. With a preponderance of the evidence, you put all the evidence that he's responsible on one side and all the evidence that says the defendant's not responsible on the other side. If it's in balance, the defendant wins. But if there's even one more grain of sand that says he's responsible than not, then the plaintiff wins. So it's truly, you put everything on the scales of justice and see if they tip at all. Criminal case, you need a whole lot more than just slightly tipping the scales. There has to be a much more significant level of evidence. The reality is that in the criminal trial, the prosecution failed to prove their case beyond a reasonable doubt. I'm not even sure they proved their case by clear and convincing evidence. Very honestly, the investigation of that case was so badly handled. Every time they had the chance to do it right or do it wrong, they did it wrong, which made it very, very complicated. I've seen people say the 51% rule. It's really more the 50.1 or 50.0001. Like I said, it is one more grain of sand, just that one little tiny bit over. As long as you are over 50%, then the plaintiff can win. You just have to tip the scale, but it doesn't have to be a whole percentage. It can be a tenth, a hundredth, a thousandth of a percent, just that one scintilla more that says you're right. In addition, O.J. Simpson is probably the worst witness you will ever want to see. Whereas in a criminal trial, he didn't have to testify and the prosecution couldn't call him because he had a Fifth Amendment right against self-incrimination. He could not be compelled to testify against himself. Once the criminal trial was over and he was found not guilty, he could say anything he wanted and they couldn't prosecute him. Because having once been prosecuted, double jeopardy bars you from being re-prosecuted for the same crime. So he could write a book. He could have walked out on ups and said, ha ha, I did it. Yes, he did write a book. He wrote a book that said, what if? Nobody really knows what's in the book because for a variety of reasons, the book ended up not getting published, etc. Exactly. If I did it, this is what could have happened. In the civil trial, they could compel him to testify. He no longer had the Fifth Amendment to stand behind because having been found not guilty, he couldn't ever be tried for those crimes again or even held responsible for lesser crimes that were included in what he was charged with. And therefore, since there was no likelihood that he could lose his life or liberty by being forced to testify, they could require him to testify in the civil action. And as I say, he's a very poor witness, which makes things a lot more complicated. In general, federal courts cannot interfere with or contradict the actions of a state court, and state courts can't interfere with or contradict the actions of the federal court. If you don't like what the federal court did, you can't go try to file that case in state court to get a different result, or vice versa. The one exception is that if you have a state case and you exhaust all of your appeals, that is, you go all the way to the highest court in the state, and you have a genuine federal question, you have a right to file a discretionary appeal with the U.S. Supreme Court. the Supreme Court's ability to hear that case is based solely on the existence of a federal question. In a criminal case, those federal questions generally revolve around the constitutional rights, excuse me, of the defendant. That is, unreasonable searches and seizures, or the rights against protections against self-incrimination, or the right to an attorney, or cruel and unusual punishment. Those are the provisions of the U.S. Constitution that pertain to criminal prosecutions. If you have one of those constitutional questions, you can appeal to the Supreme Court and they can choose to take your case. On the civil side, the ability to appeal a civil action to the Supreme Court, once again, depends upon whether you have a genuine federal question. In this last session of the court, they had a criminal case that didn't revolve around constitutional issues, but arose in Oklahoma that pertained to whether a federal treaty with a Native American nation invalidated the ability to try the case in a state court, but rather required that the matter be heard in a tribal court or in a federal court. And it turned out that the U.S. Supreme Court agreed that the treaty was still valid and in effect, and therefore that about 90% of the city of Tulsa and the surrounding area is considered Native American territory. That is a Native American reservation, wherein the federal law pertaining to what law applies within that area would be in control, and a state prosecution of a member of the tribe would not be a valid criminal prosecution, and that case would have to be taken up in an alternative forum. So we have those differences that apply. Next time, we will talk about the courts as protectors and finish this chapter. For next time, that is on Tuesday, if you would also read chapter 2. If you don't believe that you will have your book by next week, if you will email me again at the email I am putting in the chat, I will send you, sure that's right, yeah, chapter 2. So you will have both chapters that you need for the first test. We're going to be discussing chapter 2 for the next several weeks, so you'll have time for your books to come in. So if you will send those out, I will try to get those done. It probably won't be until tomorrow, but I will try to get those out to you before the weekend, so you'll have the weekend to read the second chapter. Tests will be given through Blackboard. They will be multiple choice. They'll be part multiple choice, part matching, part true false. All of the lectures are recorded. The assignments are all reading. It's reading and tests. Does anyone have any other questions? If not, I hope everyone has a great weekend, and I will see you next week. I'm going to go through and just verify that I'm not missing anyone who came in, but you are very much free to go. Thank you so much. Those of you in research, I will see you shortly. Okay. To keep Sheila, I'm still missing, and Elizabeth had a conflict. Okay. Laurel, I don't have. I gotta check Laurel. Nora. Do not have Nora. You can access the recordings for this class through the class lectures tab. When you click on that tab from the main page, it'll be on the left-hand side. The Blackboard Collaborate page will come up. You'll see on the left-hand side of your screen toward the top, there'll be 3 horizontal lines. When you click on those lines, there'll be a drop-down menu, and one of the links on that menu is recordings. I will also, over the weekend, be sending out emails with the direct links to the recordings for each of the classes, but you can access them from that place more quickly than I may be able to get the information out. Please note that just because we've finished recording doesn't automatically mean that the lecture will be posted immediately. Blackboard processes the recordings and then posts them, and so it can take anywhere from a couple of hours to even up to 24, sometimes 36 hours for them to post. I have noticed that all of the lectures from earlier this week have been posted so far, so this lecture should be available shortly. I just don't have a real time frame. Very good. I'm glad you were able to locate it. Any other questions? Yes, Naracha, I got you when you came in. Thank you for checking. You are welcome. With regard to studying for the test, I'm going to give you, in advance of the exam, a test review, as I went over when I talked about the tests when we went over the ICR. There will be a test review, but partially orally and partially in writing, that will tell you exactly what you need to study. Yes, I did mark you present, Kayla. Thank you for checking. I'll be loading the attendance into WebAdvisor later this evening, but I have you on my written roster. Thank you so much for checking. Any other questions? The test will cover what's in the book and anything that we discuss in class. It may or may not talk about individual cases. The examples I gave today, for example, probably are not on the test. There are other cases that are also in the book and that will be significant in the lecture. So it will vary depending upon the subject matter, but I will be going over in great detail what it is you need to know. So you should not have any trouble knowing what to study for the exam, and you'll have at least a week between when I give you the review and when the test occurs. So you'll have a chance to start studying and then come back and ask me additional questions. Does that help? You are welcome. Have a great evening. Okay. Bethany and Amanda. Did not have Amanda. Okay. All right. I can leave.